There are essentially three hearings in the financial dispute resolution process. The first hearing is a first directions appointment. The first directions appointment is the hearing at which the court tries to get everything in order so that at the two hearings that follow, decisions can be made. I want to talk about how to prepare for the hearing and what actually happens at the hearing. In terms of preparation, a lot of it will have been set down for you in a document called Form C. Form C sets out, when you receive it, that both sides have to serve on each other and file with the court a Form E financial statement. That document's meant to include all the financial information the court is going to need to decide your case. So it will include, for example, when you are married, when you are separated, whether you have children. It'll include whether you have any properties and whether there are mortgages on those properties. It will include what both sides earn, and is also inclusive of various sections where you can set out other facts that you say should be taken into account in the case. So those will have been filed with the court and served on each other. And once those have done, you can prepare the other documents that are required for the first directions appointment. So there'll be a statement of issues. So having served your Form E on the other side and having received theirs, you will, for example, be able to say whether there's an issue over what the value of a property is. So that could be the first item in your statement of issues. You can say whether there's an issue over what the incomes are. That may in particular be an issue in a case where one of the parties is self-employed. For example, a person who is a self-employed builder may say they earn a certain amount and the other party may say, no, that's not right, they in fact earn quite a lot more than that. In relation to other documents, there will be a chronology. So you will prepare a list of important dates, including when you started cohabiting together, when you were married, when the children were born, when you separated, and perhaps when any significant bits of property were bought. Moving on, when you arrive at court, there is a good chance you will be nervous. Try not to be, because the whole process is very much geared up to try and reduce the nerves that people feel and to try and make it easier. If you're going on your own, the first piece of advice I would give you is to turn up early. And by early, I mean at least half an hour before the hearing is due to be heard. If you have a lawyer, very often they will expect you to turn up an hour before the hearing so that you can have some discussions before the hearing. Turning up early gives you an enormous number of advantages. The first one is, if you have some sort of delay on the way, you won't experience that stress which comes from feeling you're going to be late and feeling everyone's going to be annoyed with you. Secondly, if you arrive early, you can work out where everything is, go and see the usher, tell them that you've arrived, and hopefully go and speak to the other side to find out what they're saying about the case. Talking to the other side is very important. Although you may be nervous about it, it in fact is your best opportunity for achieving a good outcome. Talking to the other side means that you can find out what they're saying in advance, and when you go in front of the judge, you'll then be forewarned of what the case is going to be about. In many first directions appointments, you'll be able to reach agreement with the other side about what directions ought to be made. For example, it may be possible to agree what the value of the former matrimonial home is. So, for example, both sides may be able to agree it's worth £250,000. And that will save the cost of getting it valued or the hassle of getting it valued if you're trying to get a valuation where it doesn't cost anything. Speaking to the other side is also something the judge will expect you to have done when you go in. So if you're able to say in front of the judge that you've had some discussions beforehand, that will assist the judge, because the judge is likely to have a large number of hearings listed before them. So they can't necessarily afford to have all the negotiation done in front of them in court. They need the parties to have sorted it out outside court. A point in relation to talking to a lawyer on the other side. If you turn up at court and you're not represented and there is a lawyer on the other side, you could be forgiven for being a bit nervous about that. But there's a few things I'd like to say to reassure you. The first point is, lawyers know that it's not in their client's interest for them to be rude to the person on the other side. So, in fact, you may be very surprised by a lot of lawyers you meet who will bend over backwards to be pleasant to the person who's representing themselves. The lawyer's bound by a code of professional ethics in any event, and so they have a certain obligation not to be unpleasant. And they also know that if they go before the judge and the judge becomes aware that they've been rude to the person on the other side, the judge is not going to be very impressed. I, in fact, know of a number of lawyers who are arguably quite aggressive when talking to other lawyers, but in fact completely change their approach when they're talking to a litigant in person, so someone representing themselves. So that deals pretty much with preparation for the hearing. If you prepare for the hearing by setting out in your own mind, and probably on paper as well for yourself, the main points you think need to be dealt with, that'll make you less nervous when you go into the hearing because you will know what you're intending to say to the judge. So you need to have defined ideas, for example, about whether properties need to be valued, whether, for example, for the next hearing, the parties need to provide each other with sets of property particulars to show what sort of property you say you could live in or the other party could live in, and whether the parties need to provide each other with mortgage capacity calculations. So do the parties need to go to see a mortgage advisor or simply do an online calculation to find out what sort of mortgage they could get hold of? If before you go in you've looked at the other side's statement of issues and you've looked at your statement of issues and you've tried to reach agreement, but if you're unable to reach agreement, you then know what the issues are and what you're saying about them, you'll be much less nervous and you're much more likely to have a successful first directions appointment.